The promoters of a new building society wanted to call their new building society the 4th South Melbourne Building Society. They applied for registration under the Building Societies Act 1874 in Victoria. There was already a building society called the South Melbourne Permanent Building and Investment Society and Deposit Institute. The Registrar of Building Societies refused the new society's application because the names were too similar and might cause confusion. The applicants challenged this decision, but Justice Holroyd pointed out that the court could not simply change the registrar's decision. The registrar had properly exercised his power under the legislation, even if the court disagreed. Instead, the applicants sought to make a clever technical argument. The relevant section in the statute said, "No society shall be registered by a name identical with that by which an existing society is already registered, or so nearly resembling the same as to be calculated to deceive." The Act contains a definitions clause which defined an existing society as any building society existing at the time of the passing of this Act. On a strict interpretation, this meant that the already operating building society in this case was not protected, because it was formed in 1877 after the Act had commenced, so it could not be an existing building society. Justice Holroyd was not persuaded. He said, interpretation clauses must themselves be interpreted reasonably, to promote and not to defeat the purposes of the Act which they are intended to elucidate. The purpose of the legislature to prevent any registered building society from bearing a name identical with or too nearly approaching that of any other similar society then existing, whether registered before or after the passing of the Act, cannot be mistaken. His Honour stated that in many cases interpretation clauses specifically stated that their definitions operated unless there be something in the subject or context repugnant to such construction. In other words, the definitions were to operate unless the context made it clear that the definition should not operate in a particular instance. His Honour found that this was the case even if the Act did not specifically state that restriction. From this case, we learn that interpretation clauses assist the court to understand the meaning of words in the statute, but if the context demands another meaning, the court can use another meaning. Ultimately, the registrar's rejection of the application was confirmed.